Hi, this is David Arietta, and I wanted to go over today a few considerations for corporations who are considering filing for bankruptcy relief. When I meet with a prospective corporate client, I want them to fill out some questionnaires that I provide and provide me with certain documents such as profit and loss statements, balance sheets, accounts payable, accounts receivable reports, and then we can have a discussion over what are the goals of the company. Some of these corporations at that point in time come into my office where they are already closed. Some of them are coming in with an expected close date, and others are actually a viable company and there are just some problems with cash flow and they just need some time to get back on their feet. So for corporate clients, their options generally boil down to Chapter 7 if they're intending to go out of business or they're already out of business. In Chapter 7, once we file the case, they cannot operate, and a Chapter 7 trustee will come into the picture and see if they can liquidate any assets, any remaining assets for the benefit of creditors. The other option for corporations would be a Chapter 11 reorganization. Those allow the client to stay in control of the company and allows for one of two things: either for them to do an orderly liquidation of assets over time, but far more common would be a structured reorganization, which is basically a plan of reorganization that's proposed and allows the company to possibly retain all of their assets, to regroup and pay cents on the dollar to their general unsecured creditors. So in recapping that, for corporations, we're generally either going to go with a Chapter 7 bankruptcy or a Chapter 11 bankruptcy. The other option I sometimes will consider would be no bankruptcy for a corporation. Sometimes there are situations where it's just not prudent to file a Chapter 7 bankruptcy for the corporation. For instance, I might have a company that's has been out of business for several years, and there might just be one or two creditors out there. It might just make sense to let the company not file bankruptcy and just notify those creditors and state that the company has no further assets and there's nothing to collect, and essentially the company's judgment proof. The other consideration is personal guarantees. If a company has a lot of personal guarantees where the owner signed for leases or contracts or loans, that could be a problem, because even if the company files Chapter 7, those creditors are going to still come after the owner of the business. So sometimes we might strategically decide that we'll just not file a corporate bankruptcy. We'll just focus on trying to file bankruptcy for the individual and therefore include all of the potential corporate debts in the individual's filing. So those are the key considerations for corporate bankruptcy clients. If you have any further questions, contact me at 925-472-8000. My office is in Walnut Creek, and I service clients throughout the greater Northern California.